And it is all about justice we are talking about, Sharmain.
Good morning. Our guest, as we're going to discuss the controversial, well, it has become controversial after it was passed in the House of Representatives. I'm sorry, and the Senate on Tuesday. It's the bail legislation. And our guest this morning is Attorney Gerald Ramdeen, total local guy, graduate of the Hugh Wooden Law School. His areas of law, he's constitutional law, and on his resume that he sent to us, judicial review of administrative action, constitutional law, human rights, prison law, resentencing, and review of detention of juvenile offenders and persons sentenced to life imprisonment. Of course, his current and recent client list ranges from the government of Trinidad and Tobago to Yassin Abubakar and the Jamaat al-Muslimin. So that tells you he's been all over. We are looking at the bail legislation mainly in light of the complaints that arose after the legislation was passed. And this dates back, Mr. Bishop, to 1994, when it was first introduced, as it was one strike and you're out when bail was denied. The original Bail Act provided that a person charged for any offense other than murder, treason, or piracy or hijacking was eligible to be granted bail. In 1994, the Parliament modified this to 3 strikes and you're out. In 2005, they added kidnapping to the list of crimes for no bail, and as well as rape, manslaughter, shooting, and robbery. Then if you had 2 convictions, you're out. A sunset clause was introduced for 1 year. 6 years later, in 2011, people charged with offenses under the Anti-Gang Act would be denied bail for 120 days. And in 2014, it was added sexual offenses involving a child, perverting the course of justice, offenses under the Larceny Act and the Malicious Damage Act, punishable by a prison term of 10 years or more. And then the Bail Act, the Bail Bill of 2015 goes further. It restricts bail for certain offenses involving the use or possession of a firearm. These most recent amendments to this bill would expire on August 15, 2016. But that for many people, that sunset clause in the bill is no consolation, because they're seeing where rights are infringed, constitutional rights are infringed.
Well, let us first of all welcome Gerald Ian Ramdeen. Thank you so much for joining us this morning.
Thank you, Mr. Bishop.
And the point here is that the sun is yet to set. Every time I hear about these sunset clauses, we get some variation or some new argument to extend it. And not only that, every time we hear that this is for a limited time, as Sharmain just illustrated, we get more being put in the bill. Many are arguing that justice delayed is justice denied. That is the basic tenet and the issue that we started with human rights. What is it? This legislation purports to restrict the granting of bail to an accused person by not permitting that person access to a court of law to hear an application for bail for as long as 120 days. If I do this correctly, we are talking about 4 months. This is 4 months under ideal conditions, under legislated conditions. Here's what the Law Association is saying. The reality is this can go for up to 2 years for the case to be made, which means that the argument is after 120 days you can apply to the court for a hearing and bail. But what? I'm innocent. Am I not until proven guilty? And if I am innocent, am I to be denied the right to apply for bail is my question.
Okay. Good morning to all your listeners, and it's my pleasure to be here. Today's Easter Sunday, and let me wish all your listeners a happy Easter. Now, if you would allow me, before we actually deal with the Bail Amendment Bill 2015, if I can just set the legal framework in which this must be considered.
Please. Because
it can't be that we can have a conversation and not understand where the Bail Amendment Bill fits in to the legal framework of what our legal system provides.
Yes,
so if you would just give me a few minutes and let me do that for the education of ourselves and our listeners.
Sure.
And first of all, we must understand that what we have in Trinidad, we have a constitution, which is our supreme law, and it says so. And that constitution really represents, some may consider it, some call it the ground norm, some call it the bedrock that binds us all together as a society. But what it really does is that the constitution is really a social contract between the state and the citizen. Mm-hmm. And I think one of the things that has evaded the conversation about the chipping away at the fundamental rights provisions, because the response of the Law Association is one which says that what we have is an over-the-time incremental chipping away at the fundamental rights. I think that is the exact term that they used. Now, Mr. Bishop, we must understand that our Constitution guarantees certain rights to all of us as citizens. And the guarantee that is given in the Constitution in Section 4 and 5 are guarantees that we must understand in the legal framework of a Constitution based on the Westminster model is one where those rights are not absolute. The Privy Council has said in a number of cases, the most celebrated one is the Equal Opportunities case, which was Surat. And in Surat, what the Privy Council wanted to make clear was that all of the rights that are guaranteed, even the right to life, which perhaps is the most fundamental of our fundamental rights, is not an absolute right, because the right to life, the right to security of person, and our right to liberty those three rights, which are the first rights that are enunciated in the Constitution, are rights which can be taken away. They are guaranteed, save and except by due process of law. So any citizen who is convicted of murder in our jurisdiction, that person can have the right to life taken away according to due process, because in our legal system, if you murder, the mandatory penalty for murder is death. And therefore, it is not even the right to life we can say is an absolute right. So we must understand those rights which the Law Association set out as being the right to be brought before a judicial authority, the right to be brought, the right to bail, and I think those are the rights that they set out as being the rights which they say are being incrementally chipped away. They say that what we have is that the three rights that they guarantee, the constitutional guarantees of reasonable bail, coupled with the presumption of innocence and the right to be brought promptly before a judicial authority, are the rights that they say are being eroded by this legislation. Now, one must always look at the legislation to see what is the legislative object of this piece of legislation. And from the object of the legislation, it is that the executive has taken decision, the legislature has taken decision to pass in Parliament legislation that says we will restrict the grant of bail to persons who commit offences with a firearm. And for the purposes of the education of the listeners, we must understand that this is limited to three types of categories. The first is you have a shutout provision for persons charged under the anti-gang legislation. So if you are charged under the anti-gang legislation, one strike and you're out, no bail. Secondly, you have persons who have been charged with a schedule offence. And having been charged with a schedule offence, you now come before the court with a second offence with the use of a firearm. And that person, that one is not a one strike and you're out, because you have to be charged with a schedule offence and then come back with a firearm offence. So it is not a one strike and you're out. You have two chances at that one if you want to refer to it as that. And the third category of persons are persons who are charged with a schedule offence, but being charged with that schedule offence, the prosecution will intimate to the court that in the commission of that schedule offence, there was the use of a firearm. So that save and except category 1, which is the anti-gang, the two other categories specifically target firearm offences, the use of a firearm in the commission of a schedule offence. So it is not, the limitations, if you want to place it upon that, is that firstly, the second category is not one strike and you're out. You must be charged first and have a pending charge. And the third one is one strike and you're out, which is that you commit the offence, the schedule offence, with the use of a firearm.
All of us would like to have law and order given as broad a berth as possible to ensure our safety. I understand the point you make about the contract. I understand about these rights are not absolute. I do have a question, however. If I am charged, if one is charged, it is merely a charge. And therein lies the problem, because if a citizen is arrested for allegedly doing something, the fact is, until you are convicted, you are innocent. Are you in concurrence with that?
I agree.
And if you are, then should you not have the right to bail, is my question. Save and except for what you articulated a moment ago, in the case of you already have a case. And even if you have one, here is the problem. I understand why one would reach further to say, well, you already have a pending case, so we are going to give you one strike and you don't get it again. But until you are convicted of that second crime, but I don't want to waste the time there. I want to more deal with the area of I'm a citizen. I am driving my vehicle down the street. Cop sees me, pulls me aside. Cop says I had a gun. I say I didn't. Cop takes me to the station. I am now put up and I am not guaranteed, I have no guarantee of bail for 120 days. Where is my right here?
Okay. Now, we must understand the grant of bail. You can't single out the presumption of innocence and the right to reasonable bail as being paramount to any other right, because like I indicated at the outset, we must understand those rights in the context of being a social contract. You can also say, there are citizens who will be the subject of criminal offenses, the victims of criminal offenses, and those citizens will also say, well, what about my right? What about the right to the security of person that I am guaranteed to by the state? Now, the state must always strike a balance between guaranteeing to the citizens the rights which they are guaranteed under Section 4 and 5, and what is really happening here, and where really the discussion should focus is whether the state, in implementing this legislation, is striking a right balance between those persons who they have these rights guaranteed to and those persons who are charged with these offenses.
Gerald Ian Ramdeen is our guest here. Let me throw that question right back at you. Do you think there is a fair balance in what has been passed?
Well, the way you have me here in my capacity as a lawyer, and I just want to tell you that in asking that question, the answer to that question lies in a test that has been set out by the Privy Council in a case to determine whether, where there is a legislative enactment, there is a legal test that legislation must satisfy in order to answer the exact question which you've given, which is this an unfair and excessive infringement upon our rights? And there are three questions that the court says you must answer in answering that question. And let me set out those three questions. Those three questions are this. The first one is whether the legislative objective is sufficiently important to justify limiting that fundamental right. That's the first question. The second question is whether the measures designed to meet that legislative objective are rationally connected to it. And the third question is whether the means used to impair the right or freedom are no more than is necessary to accomplish that objective. And if we take the discussion into that to answer the question that you've asked, we have what the legislature have sought to do is to restrict the grant of bail to persons, like you said, for the use of a firearm, where you have offenses with the use of a firearm. Now, Mr. Bishop, I want you to understand this. The grant of bail is a necessary guarantee that is given by Section 5 of our Constitution to everyone who is charged with a criminal offense. I don't know if this has entered into the discussion, but the citizens and your listeners must understand that if you are charged with any offense, and you go before a court of law and you apply for bail and you are denied bail for any offense, you don't have the right to come back before that court and ask for bail unless there's a change of circumstances.
New evidence and so on, yes.
And what that does is that you have, at the outset, you said, Mr. Ramdeen, we are talking about 4 months. Somebody could be denied bail for 4 months. But for any offense, if I go before the court and for some reason the magistrate denies me bail, I can't go back before that court and ask for the grant of bail in the magistrate court or the high court until there is a change of circumstances. That could take a year.
I am not asking for a piece of legislation, Mr. Ramdeen. I'm asking for a person sitting there and hearing me. I understand what you're saying, but I am asking for, in that 4 months, that I have the right to look at Mr. Gerald Ramdeen, let's just say he is the judge, magistrate, and say, listen, what the police is offering is not accurate. I give my, I submit to you that I am innocent. And then let it be Judge Ramdeen's decision to deny me bail as against a piece of legislation that is not hearing me, that is not seeing me, that's not looking into my circumstances. I'm not getting the chance to even make a case for myself, is what I am saying.
Well, Mr. Bishop, let's take it let's go one step back and say, when these offenses that are targeted, one must ask, why is it that the legislature has targeted firearm offenses? From the statistics from the police, we see that 75% of the offenses that are committed are offenses committed by firearms. Homicides and all the other offenses, serious offenses, are offenses that are committed presently by the use of a firearm. And in this case, one must ask, well, why is it that we've targeted these persons? Why is it that the legislature has targeted these persons? And from the Hansard, from the statements that have been made in Parliament, both by the independent senators and the opposition, and also the government senators, and the Attorney General, it is this. When you have persons who commit anti-gang offenses or members of a gang, what happens is that when those persons are charged, when they get bail, those persons come back out immediately, and they would do one of two things which the record shows. They would be repeat offenders, or they would interfere with the system of justice that you have in place. So they will intimidate witnesses, They may kill witnesses. During that first initial period when the police have their antennas up and are looking to try and get at the crime and find out who the offenders are, that is when the offenders, the persons who are charged, come at you. They kill the witnesses. We had a situation of about 10 years ago where when Dolce and the gang were about, from the time somebody is charged, you will hear the witnesses are killed. And where do you go with that? So that what Ms. Baboolal indicated from 1994, when you had the chipping away of the rights, you would see that you can't say that the timeline that Ms. Baboolal has indicated there and the offenses. Take, for example, the scourge that this country had when we had kidnapping. And when we brought kidnapping into under the Schedule 2, and there was kidnapping for ransom, no bail, you can see that there were results. And when you look at the timeline and you see all of the incremental, if you want to say chipping away of the fundamental rights, I am not saying it from sitting here, but you must see that the records from the police service show that having regard to the fact that legislative enactments have been put in place, there is a fall in serious crime from the statistics of the police, and there is a fall in these schedule offenses.
Gerald Ramdeen, you make good representation to the contrary, and I know Sharmain is jumping to get in there, but I'm looking at a whole slew of other offenses that are in the 2015 bill, the restriction in certain areas, including possession of firearm, larceny of a motor vehicle, burglary, housebreaking, rape, drug possession, etc., etc. But I'll let Sharmain get in, and I will continue. I'm sorry, Sharmain.
That's okay. Having referred to 2005 with the we added kidnapping on the list, on the schedule. What I would say, and Bishop, is that what has happened in this country, crime has turned us all law-abiding citizens into one huge lynch mob, so that we are there. So that if rights are eroded, it's an emotional response. We see rights being eroded and we just let it pass. Case in point was in the Senate on Tuesday, when the bill reached to the committee stage. I was sitting there looking at it and it just passed like that. Yeah, all 5 clauses passed without debate at the committee stage. It was all agreed to. Usually it's at this stage that you bring amendments, even the independent senators who objected to it. You understand? Did not bring any amendments to say, well, this is an alternative. This is how we can do it. So that's putting it into context there.
I might infer from that you mean that we're looking at a knee-jerk response to a situation.
It would be based because, if you look, as he said, the timeline from 1994 to now, because kidnapping was so brutal in 2005 that it was the response, So, but I want to go back to, in 1994, when it was 1 strike and no bail for 120 days in the first instance. Does this still exist that if the state starts to prosecute within 121 days, the person will remain behind bars for up to a year, within which time the case should finish? If it is not, then at the end of a year, they can apply for bail. Before you just answer that, what I'm saying, this is just a year on paper, but we know the justice system, how clogged it is and how slow moving it is. How then do we bring the legislation into our real situation?
Right. Now, Sharmain, one of the things that I want to emphasize is that I share your concern that legislation like this, which seems to erode, and perhaps erode might not be as drastic a word as we should use, can pass through our parliament with no objection. And perhaps that stems from the fact that, like I indicated at the outset, our constitution was one that was evolutionary and not revolutionary. And therefore, in a large number of cases, our citizens don't really take seriously the erosion of our rights. And that may be because, like I said, our constitution was one that evolved out of a series of Westminster constitutions when there was the grant of independence. So we really haven't been a society that fought for our rights and value our rights like in other societies where they had to fight for their rights. And in that aspect, I share that concern that you have many pieces of legislation, not only this piece of legislation, but you don't have the kind of education of the public, the education of our citizens to understand what the consequences of these pieces of legislation are to them.
And perhaps the quality of legal minds in the upper house as well as in the House of Representatives.
Well, let me put it this way. I share the concerns that the Law Association has highlighted in their press release. But what I can say is that those concerns, for example, like Mr. Bishop says, I'm going to be behind bars for 3 years. What really happens is that if you really do the research, you would realize that there are persons who are waiting, who have been committed to stand trial for murder. and they are sitting there in the remand section of the prison, which is the worst section of the prison. And they sit there for 5 and 6 years, waiting on the director of public prosecution to only make a decision as to whether they're going forward with this or not. So let's look at the bail legislation in the whole scheme of things. We need to reform the entire system. We need to have change in the entire system. Now, to answer the question that you asked, I found that one deficiency in this piece of legislation is simply this. One of the concerns raised by the Law Association was that, well, it takes a very long time to analyze these firearm exhibits that go to the forensic. Well, there's a very easy way to solve that, which I don't understand why it hasn't been considered, which is this. Why is it that you don't give the accused the right to say, I accept that is a firearm, let's move on? Why do you have to wait 4 years for a scientific officer to test a gun, point it in a barrel, shoot it, and write a report and say this is a firearm?
And
How long does that take?
But even so, our firearms, anything to do with firearms in Trinidad is awfully limited in that there's no real forensic testing that you can trace a gun or you can undo that. But at least it's not put into play in the courts.
Well, what I can say is let the systemic delay in relation to the Forensic Science Center is one that from where I sit, is one that can be easily addressed. The Attorney General said they're going to outsource it. Well, that is one way you can do it. But if you outsource it, you have to know that you have the capacity to do it. And when will it come in? When will this outsourcing come into play? Is there a plan that is already put in place? How is it going to be done? What I'm saying is a simple clause in the legislation that says when you bring an accused, for example, like Mr. Bishop says, I driving down the road, the police stop me and they say they find 1 kilo of cocaine in my car, right? I say I don't have it. What use is it going to be to me to determine whether that is cocaine or not? It's of no use to me. In 99% of the cases, no accused person is going to challenge whether this is marijuana or whether it's cocaine. And that is what is keeping up that person there for so long. If the person comes before the court and at the first hearing says, Your Worship, Mr. Bishop, I am not concerned about whether this is marijuana or not. I wasn't there when this happened. Let's move on with the trial. You start your trial and you go on straight away. Now, another thing that you've addressed is that you have this person sitting there for 4 months in conditions that the courts in Trinidad have held to be unusual and cruel.
Dehumanizing.
Madam Justice Carol Gobin, I think it's almost 8 years now, has said that the conditions in the remand section of the state prison amount to cruel and unusual punishment. That citizens who are presumed innocent, as Mr. Bishop has that concern, are being kept in conditions that are cruel and inhumane. And why is it that nothing has been done? The bail amendment bill is just one aspect that is going to put persons there to suffer under those conditions. It may be innocent persons for that period of time. Why has nothing has been done? Why do we still have persons suffering under those conditions at Port of Spain? I mean, if as a society we can condone that, then something is wrong.
The learned voice you're hearing is that of Gerald and Ramdeen, attorney, and we are talking about the bail restrictions that recently passed. Presidential candidate Michael Dukakis got in trouble when the issue of how to deal with a rapist was raised. And I mentioned that because it comes in a specific area of something I'm about to ask you. He was asked, if it happened to your daughter, what would you do? I ask you, with the restrictions we have now, with this no bail legislation to just pass, how comfortable would you be if your brother, sister, somebody in your household was held and had to wait for 120 days?
Well, that is a question that would provoke a lot of emotional responses depending on where and to whom the question is asked. If I were to be put in that position, obviously the prejudice that I will suffer having been placed in a position like that, where you are denied your liberty for any period of time. Someone who is innocent, if their liberty is denied to them for a minute, an hour, right, it is too long. We're speaking in the context of 120 days. But when you ask that question to the victim of somebody who is shot, if you put me in the position of my daughter or my son being shot, right, or a member of my family being shot, and that having happened to them, you witness that. And then after you witness that, that person who committed that offense, after 2 or 3 days when that person is charged, in 7 days, they go before the magistrate and they're granted bail. And they come to your home or my home and say they will kill me if I go and become a witness in that matter. Then there's something clearly wrong about that.
And I am fully in agreement with that. I share exactly your sentiments, save for one thing. They get a chance in 7 days to go before a magistrate. And that is where, that is at the center of this, to me, is what bothers me. It is not anything, I mean, we understand, you've got to put deterrences up. Society's got to make rules for itself. I understand some things are flexible. You have to adjust. We evolve all the time. I do have a problem, however, with someone being innocent, being held, and not having access to have a bail request for 120 days.
The real question which we must answer is whether as a society we are prepared to sacrifice the rights of some in order to get a greater benefit to the others. It's really like the utilitarian principle that whether we will accept that for the majority of us, this is a provision that will make us or carry us forward a better society. And to say that, we must also understand that this is a piece of legislation that has a sunset clause, and it says in 16 months it comes to an end. You will have a period of time where I think that it having been enacted for 16 months and you have the 120 days denial of bail, if it is that you see results, Mr. Bishop, if in 16 months you see results that tell you firearm offenses have dropped significantly, you see that, what do you do as a society? Do you continue it? Do you say we've reaped the results? There is, at each stage of the process, there is always going to be a balancing act.
I am going to be very happy that we have people like you making the case for it, but even if you come back to me and show me in 6 months, in a year, I'm going to hold my position that there is no way I'm going to sacrifice the possibility of an innocent person being held for 120 days. This does not take away, dilute from your representation. I just hold very strongly that it is difficult for me to find any place in me that as a citizen, I am held and I don't have redress. On the issue of bail, I cannot, there is no way I can countenance that. It just works against my system.
Okay, so one of the things that we have here is that the Attorney General is, when all these issues were put to him, as Mr. Bishop's issues were put to him, right? He's calling for us to expedite setting up a gun court in Trinidad and Tobago, which should be able to deal with things, which should have been in place even before I would suspect the bail legislation was in place. Why would it have taken so long for us to set up a gun court in Trinidad and Tobago?
Just like I said again, to bring all the facts into play. In San Fernando and in Port of Spain, I don't know if the citizens know that, but in San Fernando and in Port of Spain, there are 2 magistrate courts that deal specifically with firearm offenses. Administratively, the judiciary has set up 2 courts, one in Port of Spain and one in San Fernando, that deals specifically with firearm offenses.
Okay, can I ask then, as a follow-up, is even before, I'm sorry to even interrupt you, but are they regarded as gun court, or is a gun court a specific thing that has to be set up with legislation and all of that?
Well, let's say de facto, it is what you can call a gun court because it deals specifically with firearm offenses. The concept of what the Honorable Attorney General may understand to be, if he wants to set up a gun court, because this was something that was raised a number of the seminal case on separation of powers, which is Hines and the Attorney General of Jamaica in Commonwealth Caribbean jurisprudence, is one where the Jamaican authorities way back in the early 80s tried to set up a gun court. And in so doing, they found that it was in breach of the separation of powers because of the way in which those persons who were to man that court were appointed. But it is a concept that one must understand that in order for us to cure the scourge of crime that we are suffering in this country, it is not something that can fall at the feet of the legislature alone. We must all play a part, so that the judiciary must play a part as well. The legislature must play a part, the executive must play a part, and only when all hands are on board that we can come together and find the correct balance in terms of securing everyone's interest. Because, for example, this bail legislation, if we go back to that, you have, when this was originally in the House of Representatives and it was piloted, one of the reasons why it was piloted and it seemed to be so draconian is because, without saying so in the public, police prosecutors and prosecutors in the High Court were saying, but we have these people who we know are gang members. They come before the court. We do our job. We charge them. We bring them before the court. And like Mr. Bishop said, in a few days' time, they go before the magistrate. They have 4 and 5 convictions. And the magistrate gives them bail again. The 6th time you get bail. You go and commit again, the 7th time you get bail. So that one will look at the rights of that limited group of persons and say, well, we cannot erode that right to liberty anymore, or we cannot erode the right to reasonable bail anymore. But what do you say to the prosecutor who says, I have a victim I am prosecuting this person, and I have victims who say, this man who has committed 5 offenses. What do you do when someone says to you, Mr. Ramdeen, you are the prosecutor, and this man, Mr. Bishop, has committed 6 offenses. This is his 7th offense, doing the same thing.
But Mr. Ramdeen, I submit to you that maybe you and I and we generally should be looking at the magistrates who see this behavior and they don't refuse the bail.
Well, Mr. Bishop, that is what I'm coming to, because like I told you, when that question is asked and that person, that victim, when that victim comes and talks to the prosecutor after they leave the court and they say, but Mr. Bishop, how this magistrate could grant this person bail after 5 times they shoot somebody and the 6th time they come and the magistrate still grants them bail? What I will tell my family when I go home? What answer do you give to that person? So whereas it is an intrusion upon the rights of the person who is charged and enjoys the presumption of innocence, we have to find as a society a solution to fix the problem that magistrates are granting bail to people who are repeat offenders over and over and are not properly exercising their discretion judicially to determine whether this person should be granted bail or not.
In all fairness, I would tell you, Bish, that repeat offenders have been a major problem for us in Trinidad and Tobago, in the sense that the jails, people go in and they come out. So
revolving door, yes.
Yes, revolving door. So you're churning out criminals all the time.
And I just want
so
to...
that's from the perspective of the law-abiding citizen, but more so the victim of crime. As I've said before, that we've become a lynch mob, to the point that I just needed to just put this point out there, that even a criminal sitting, well, an alleged criminal, he's innocent until proven guilty, sitting in a court in front of a jury would think he hardly has any chance, because the jury comes from the pool of the people. We all a lynch mob. We're ready. There's hardly any justice in the real sense. We're ready to send them down to jail. They just look like it, and we're ready to send them down.
You are going to find kinship in my thinking and Mr. Ramdeen's at an astonishing level, because I am at the core, I believe, even more conservative than he is. I do, however, find that all these things take into consideration, even your point of how do I answer somebody that the magistrate or the judge is doing so and so, the magistrate in this case. And I go like, maybe a review of these magistrates should take place, because now to have me, the innocent citizen, in a situation where I can be held for 4 months because of the questionable practices of a magistrate, I find that's unfair. I mean, me personally, you make the point that there is a very good case to be made that we cannot put these people back on the streets. I buy that. You make the point that there are some people we should deny bail. That's already in here. Some people that should be denied bail. Go ahead and use the legislation that is already in place. But now to come and tell me that I have to wait for 4 months, I am sorry, Mr. Ramdeen. There is no part of me can see that. I want to walk the streets. I want to go out. I want to feel safe. But I want to feel that if I am arrested and given the police the benefit of the doubt, if I'm arrested by a police officer because he thinks this is the case, then that's fine. He's doing his job. Now give me a chance to sit down or stand up before a magistrate and say, I am innocent and I need some time to get my defense together and so on and so on and so on, and I need bail.
Okay, there's something that I want to go back to. Are professional bailers still in existence? Do we have professional bailers?
Well, let me answer that question very carefully, Ms. Baboolal. Is this: you are not supposed to have professional bailers, but it is known that is a very essential part of our system, and for good reason. So, for example, like Mr. Bishop says, I mean, we must always connect back to the reality. There are many poor people in this country.
Which I would want you, because I want to bring the ghost of Dana Seatal into this discussion. Pull back her wisdom, because in research I came upon a column that she had written, in 2013. And for example, the same thing that you were probably going to explain, Gerald, is that if this means, and the situation is even worse where bail is available and exists, okay? This means if bail was fixed at $50,000, the payment to have that deed used as security is a minimum of $5,000. This is bail as we know it for the average person who may not have a clear deed, since most likely, even if he owns his house, he has a mortgage. Our Bail Act states at Section 18 that it is an offense where a person agrees with another to indemnify that other person for any liability that the other may incur as a surety for a person charged with an offense. In other words, it is an offense both for a person to pay another to take bail and for the person paid to do so to take bail. The law thus prohibits professional bailers. The entire system needs to be revised to legitimize professional bailers, as has been done in other countries. This is for offenses where you can have bail. And there are a lot of poor people languishing in jail under the same circumstances with no access to bail. So it outside of the amendments to the bail legislation, Gerald.
I can tell you, Mr. Bishop and Ms. Baboolal, that if you don't have the system of what we call professional bailers, which, as you correctly indicated under the Bail Act, is an offense, both to the person who is taking the bail and for the person who is accessing the bail, then you'd probably have to bill double the amount of jails that we have here to hold persons, because I would estimate that perhaps in about more than 75% of the cases where people actually access bail in this country, it is by means of a professional bailer.
Now I understand why he chuckled and hesitated before responding to that, because on the one hand it shouldn't be, but on the other hand
It is.
it is.
It is. And you know,
The sad reality.
when you look at, Mr. Vira, you take a very stiff, hardline stance on the fact that you guard your liberty to the extent that you think it shouldn't be eroded in any way possible.
I'm not too sure. That's exactly what I'm saying. I am saying this area of it, and I know if you were my counsel, you would advise me to be sure I am not misrepresented in this area. I am saying give me the access to bail. Erosion, as you said, nothing is definitive. Everything is evolving. I'm in agreement with
what
that.
you're doing is that you are what you are doing, and you might say it might be highly technical, Mr. Ramdeen, but what you are doing is that you are having access to it, but I'm limiting your access to it to 120 days. And in balancing that off, that is the balance that the legislature have struck in this particular case. Now, we must understand in answering the questions as to whether this is a permissible or impermissible erosion into our rights, that one of the fundamental bedrock principles of our Constitution is that you are not entitled to a legal system that is infallible, but you are entitled to a legal system that is fair. And infallibility is not a guarantee that is given to any citizen, because it can be me today, it can be you tomorrow.
That's right.
Every one of us at some point in time can be subject to some wrongful action by the state, and there are mechanisms in place that give us a remedy when that takes place. Ms. Baboolal, of course, would be no stranger to that. But from Maraj and the Attorney General, when former Attorney General Ramesh Maraj was unlawfully imprisoned way back in 1977, took his case all the way to the Privy Council. At that time, the Privy Council said, you are not entitled to a legal system that is infallible, but you are entitled to a legal system that is fair. So your legal system will obviously cater for errors, and therefore that is why you have a system where you are committed in the magistrate court, you stand trial in the high court. If you are convicted, you go to the Court of Appeal and you argue that your conviction was wrongful. If the Court of Appeal doesn't hear you, you have a right to go to the Judicial Committee. And if the Judicial Committee says that you are rightfully convicted, then you cannot say that it was unfair, because the highest court has said that it was fair.
Sometimes you make my case for me. I'm a taxi driver, and somebody put a gun in the back seat. Probably left the car, forgot it, or maybe he's in the car. And no, he left the car, and I'm driving alone. Police officer stops me, looks in the back seat, sees the gun, picks it up. I'm a poor man trying to get my family, make a living for my family. And you want to put me, not you, but this legislation want to keep me in jail for 4 months before I can even have a discussion with a magistrate. That is what I'm talking about.
And those are the sacrifices, and those are the things that we must put in the balance to determine at the end of the day whether the balance that we strike is the right balance. Is it that we should cut down the 120 days? Is it that we should increase it? Is it that there is some safeguard that we can procedurally put in place so that we can emphasize that the prosecutors, the fact that you say in 120 days you ought not to be granted bail, it should be an amber light to prosecutors and the prosecuting authorities to say, let us get on with this and let us really see whether these persons who are charged with these offenses under this particular piece of legislation, because in a proper working system, Mr. Bishop, one would expect that if you have legislation that is draconian as this,
and this
you would
is draconian
and this is
indeed.
draconian legislation, you can say, can the prosecutors or those who are in charge of prosecuting persons caught by this legislation make an emphasis to deal with these cases and give these cases some kind of priority, so we can see that at the outset, you might see these are the facts, but we investigate the offense. And during the 120 days, we come, for example, like in the anti-gang legislation, when the state of emergency was carried out. The DPP got the files. Persons were charged. And when they came before the court, he said, this evidence is not good enough. I don't have enough evidence. Discontinue. And that happened in hundreds of cases.
And they were released after how many days?
I am.
You can't remember.
I am sure that there were some who were released before 120 days. I think some were released as soon as the matters were called. I think on the second hearing. I know, I can guarantee to you, Ms. Baboolal, that there are persons who were released after a month. Because there are cases before the court where persons have brought claims, claiming that they were incarcerated for a month, 2 months in some cases, 3 months in some cases. But what it says is that the system can work in a situation where you may not have to wait 120 days. You may have an innocent man and the evidence is looked at by the DPP or looked at by the prosecutor and he says, I really can't make a case here.
Mr. Ramdeen talks about the legislation should be an amber light to prosecutors to get on with the business. These folks seem to be colorblind, because if you look at the time that it's taking, somebody's looking for a different hue of amber than the one I know.
Well, Mr. Bishop, that is why I said we should not simply telescope our view and focus only on the bail legislation. I think that the Law Association, the Office of the Director of Public Prosecution, the Office of the Attorney General, the judiciary, all of us have an interest to play in ensuring that the guilty are prosecuted and the innocent are set free in this system. And therefore, what we must do is that let us not limit, I would call on the Law Association not to only think about the bail legislation and see what the flaws are here. Let us call upon the authorities to do something in the prison. Let us call upon the authorities to do something in the system of bail and the access to bail that we have now. There are many, many things that we need to look after. A few years ago, there was a talk that we should have a remand court so that we don't have to take people up and down every day and carry them in a truck, up and down in a cage, put them in a cage when they reach into the court to hear, come back in 14 days.
That makes,
a
little point I must put in that we must go, but we did not talk about the strain this is going to put on the prison service, by the way.
Well,
We do have to
rightfully
get in.
so. There are concerns that have been raised by the Prison Officers Association.
Yeah.
We've got to wrap up, unfortunately. Gerald, Ian, Ramdeen, no wonder you're so busy. You make your representation quite clear. And I thank you for taking the time to be with us this morning. It is truly appreciated.
Thank you for the opportunity.
You have yourself a wonderful weekend.
Same to you.
Thank you.